So you're heading into a divorce. You've built real assets over the years, maybe rental properties, a business, or investment accounts. And now you're thinking, how do I protect what's mine? You've probably seen the ads, set up a Cook Island trust and your spouse can't touch your assets. Move your money offshore before filing for a divorce. Guaranteed protection from divorce settlements. Sounds bold, right? It hits your emotions. The video just opened your, biggest fear. Your spouse is going to take everything from you. You're now emotionally primed. You're desperate for help because you've worked hard for what you have. And after seeing their ad or listening to a video that promises divorce-proof trust, you have to have that quick fix. But here's the truth. That's not asset protection. That's a fraudulent transfer waiting to happen. Your spouse is not a creditor. I'm going to say that again. Your spouse is not a creditor. Most people lump divorce and lawsuits together, but legally they're worlds apart. And that misunderstanding is where most bad advice starts. In a lawsuit, the person suing you is a creditor. They're trying to collect money from you, a debt, a judgment, or damages for negligence, something like that. That's why asset protection laws exist, to protect you from outside creditors. But again, your spouse, they're not a creditor. They don't have a debt claim against you or your property. They have what's called a marital interest, and that's a totally different legal right. Your spouse has equal ownership rights. Think of it this way. A creditor says, you owe me money. A spouse says, we built this together. We both own this. Marriage isn't a debt relationship. It's a partnership. So when a marriage ends, the court doesn't treat your spouse like a bill collector. It's not about repayment. It's about reallocation, what was jointly built together. In community property states like California, Texas, and Washington, everything earned during the marriage is automatically presumed 50-50. In equitable distribution states like New York, Illinois, and Florida, the courts divide assets fairly, not necessarily equally based on contributions, length of the marriage, and circumstances. Either way, the court's not collecting from you. It's dividing the marital pot fairly. And that's why in legal terms, your spouse is not a creditor. Divorce courts divide, they do not collect. And that single difference changes everything about how legitimate asset protection works, especially when we're talking about a divorce. Even if it's, assets are placed offshore, family courts can and they do value those assets in the marital estate, issue divisions or equalization orders, and hold you in contempt for concealment and non-compliance. That's why divorce-proof trust marketing is so dangerous. It sells defiance of family law, not protection from creditors. Search Cook Islands Trust Divorce and you'll see endless ads promising impossible outcome. And here's the truth. A spouse isn't a third-party creditor, so normal asset protection laws don't apply. Funding a trust once a divorce is foreseeable triggers fraudulent transfer statutes. Legitimate offshore trustees like Southpac, they will freeze accounts and refuse distributions once they learn of divorce litigation. They have to. It's not optional. It's a regulatory and fiduciary obligation. They will not help conceal assets in that situation. Reputable trustees like Southpac and other first-tier Cook Island firms, they operate under strict trust company regulations. In practice, when they receive notice of divorce, they routinely place holds or freeze on discretionary distributions. So feel free to call up Southpac and others in the Cook Islands. Ask them yourselves. They do this to protect both the integrity of the trustee and the long-term validity of the trust. Because the moment a trustee helps hide assets or evade a lawful divorce distribution court order, that trust can be invalidated and the trustee can lose their license. The Cook Islands International Trust Act of 1984 gives exceptionally strong protection to properly structured trust against third-party creditors. Again, that is not your spouse. But Section 13B1B makes one thing very clear. Transfers made with intent to defraud, including to defraud marital or creditor rights, are not protected. Cook Island judges have full discretion to set aside or disregard any transfer funded in bad faith. And in real-world cases, The High Court has refused to uphold trust when the evidence shows last-minute funding or obvious attempts at divorce concealment. This is not one of those areas of laws to be shopping around for thought or want validation. The law is crystal clear in the US and offshore in the Cook Islands. So even in the Cook Islands, widely viewed as the world's strongest asset protection jurisdiction, the courts still draw a very bright line between good faith planning and fraudulent timing. We need to keep in mind that when planning actually works, real asset protection is proactive, not reactive. It's set up before marriage or long before divorce. It's built to defend against lawsuit risks, not family court orders. It's transparent, tax neutral, and legally compliant. We aren't hiding. When your intent is clean and your timing is right, those structures stand. When they're last minute or emotionally driven, they tend to collapse. I want you to meet Mr. Green. Here's a case study. A successful businessman, 25-year-long marriage, $9 million in estate assets. His home is worth $1.3 million. His wife's IRA is about $500,000. After 25 years, nearly everything is marital property. They started with nothing and built over the years during the marriage. If he moves his money offshore today, that's a fraudulent transfer, plain and simple. His real options are to protect separate assets with a postnuptial agreement and documentation, or better yet, to have planned for this beforehand, get a prenup before he was married, build joint protection structures with his spouse involved in the planning, and avoid unilateral offshore transfers that collapse under scrutiny by trying to hide assets. The goal isn't to hide assets from your spouse, it's to protect the family wealth ethically and legally from future third-party creditors. When done correctly, structures like the bridge trust and asset management limited partnerships provide lawsuit and creditor protection, not divorce avoidance. They're built long before conflict with clear purpose and clean funding. That's why they remain IRS compliant and court defensible. If someone's selling you divorce-proof asset protection, they're not selling law, they're selling fear. Real asset protection isn't about secrecy or paperwork. It's about structure, timing, and intent. And that's why I always say, you don't rise to the level of your income, you fall to the level of your structure.